I am Takeda, Director, Office of Ensuring Fair Transactions Involving Freelance Contractors, Japan Fair Trade Commission or JFTC General Secretariat. Thank you very much for the opportunity to speak today at the Freelance Act 2024 Aogaku Symposium organized by Professor Naoki Okada's lab at Aoyama Gakuin University. I would like to speak for about 45 minutes on the topic of today's symposium, Freelance Act and Future Activities, regarding the theme of today's symposium, appropriate transactions in the entertainment and creative fields. Please note that the parts of my speech today that relate to my opinions are my personal views and do not represent the opinions of the JFTC. Let me now move on to the explanation. First of all, I will talk about the background to the Freelance Act. In this context, we will also talk about the environment surrounding freelancers, including our perception of it. After that, from the perspective of ensuring fairness in transactions, I will talk about the part of the Freelance Act that relates to ensuring fairness in freelance transactions, which the JFTC and the Small and Medium Enterprise Agency are in charge of, and as much as possible about the entertainment and creative sectors. Then, finally, I will introduce the initiatives of the JFTC. This slide briefly summarizes the current status of freelance working in Japan. In recent years, the freelance working style has become increasingly common as working styles diversify, and according to a survey conducted by the Cabinet Secretariat in 2022, it is estimated that there are currently 4.62 million freelancers in Japan. And of these, it is estimated that around 2.14 million are freelancers as their main job, while 2.48 million are freelancers on the side. The graph below shows the results of a survey conducted by the JFTC and the Ministry of Health, Labour and Welfare in 2023, in which respondents were asked about the nature of their work. I think the field of performing arts creative is quite broad. The areas highlighted in red on this graph are the areas that, in my view, are likely to be mainly in the performing arts creative field. There may be people outside of this working in the performing arts and creative fields. This is just one reference for your information. I do not believe that this freelance way of working is a completely new way of working that has emerged in recent years. The rapid progress of digitalization, the increase in the number of gig workers and cloud workers, and the increase in the number of ways to work from home have certainly brought the term freelance to the forefront of attention. However, in some industries, freelance working has been rather common for some time. And in the entertainment and creative fields, there have typically been a lot of people working as freelancers, from what we hear from people in those fields. Some of the performers, directors, writers, designers, cameramen, art and costume designers who are featured in the end roles of TV programs and films, or who work in this field without being featured, may be employed, but many of those who work in this field may be freelancers. The government has so far set up a Freelance Troubles Helpline 110 to provide advice to freelancers and conduct surveys on the actual situation regarding freelance transactions. We would like to present the results of the fact-finding survey and our perceptions with reference to the documents. Our fact-finding surveys have highlighted that there are many instances of trouble in freelance trading. The graph shows the results of a survey conducted by the government in 2021. According to this, 39.2% of freelancers have experienced unacceptable conduct from a client in the last 3 years of business. The details of the unacceptable behavior of the client include: the client reduced or eliminated the quantity of the order for the client's own reasons, the amount of remuneration was unreasonably set at a significantly lower level, and the payment of the remuneration was delayed. The most important thing to prevent such unacceptable practices and to reduce transactional problems as much as possible is to keep a record of the details of work orders. This is because the records are important when checking them later. To whom, by when, where, for how much, and what work is ordered. Both the party receiving the order and the party placing the order must have a firm agreement on this and keep a record of it. This is the basis of the transaction. In reality, however, as this slide shows, more than 40% of freelancers say that the terms and conditions of business and the nature of the work are not adequately or at all presented in writing or by email. Freelance Troubles 110 helpline also receives consultation and opinions on harassment suffered by freelancers. So what has been the legal response to these issues so far? If freelancers fall under the category of workers, their working environment is regulated by the labor legislation. On the other hand, if freelancers fall under the category of business operators, the transactions between them and business operators are regulated by competition law, with a view to ensuring the fairness of the transactions. However, there has always been the question of whether freelancers, including those who work in what might be described as employment-like ways of working, are workers or businesses. In this regard, the Freelance Act defines a freelancer as a business entity that is a party to a work contract. In other words, this Freelance Act understands, defines, and regulates freelancers as a business entity. Disparities in negotiation and information gathering skills are likely to arise between freelancers who receive commissioned work as a single individual and the ordering business, which is an organization. For example, freelancers without employees tend to have time constraints, a small business scale, and a tendency to be dependent on a particular ordering business, and are not paid until the work is completed in accordance with the ordering business's instructions. Thus, it is more likely to happen that the party placing the order takes the lead in determining the terms and conditions of the transaction, such as remuneration. As individuals, freelancers are often in a weaker position in business transactions in relation to the ordering party, which is an organization. The Freelance Act aims to ensure fairness in freelance transactions and to improve the working environment by establishing common minimum rules for all transactions between clients and freelancers across all industries. However, there are two existing laws that can regulate unfair practices in transactions between an ordering business operator with a strong bargaining position and an ordering business operator with a weak bargaining position: the Antimonopoly Act's regulation of abuse of a superior bargaining position and the Subcontract Act, which regulates transactions between a parent undertaking and a subcontracting business operator. Why was it decided to create a new law, the Freelance Act, instead of dealing with these laws through their operation or amendment? First of all, in relation to the Antimonopoly Act, it is a law that promotes and protects fair and free competition in the market, and it is concerned with competition in the market. In this respect, although not introduced in today's symposium, it can be said that matters such as the development of the working environment for freelancers, such as the development of a system to prevent harassment, are not directly related to the Antimonopoly Act. It would not necessarily be appropriate to cover matters that are not related to the promotion of competition in the market. These are matters that do not fit under the Antimonopoly Act's regulations. On the other hand, the Subcontract Act is a special law for abuse of a superior bargaining position under the Antimonopoly Act. The Subcontract Act formally determines the superiority or inferiority of a trading position by classifying parent undertakings and subcontractors according to the size of their capital, thereby making trading fair for subcontractors in a simple and speedy manner. Why was this Subcontract Act not amended and a new Freelance Act created? This is because the business partners with whom freelancers do business often do not meet the requirements of being a parent undertaking under the Subcontract Act. Businesses that are not well capitalized often outsource work to freelancers. For this reason, it is not enough to regulate the parent undertakings covered by the Subcontract Act. For this reason, a new Freelance Act has been created. Thus, the Freelance Act was drafted as a completely new law. The Freelance Act is also a regulation that applies to all freelance transactions. I have been in charge of freelance law since last September and have heard from freelancers and their counterparts in many different industries. I feel that there are so many different types of freelance transactions, and even within one industry or sector, there are so many different types of transactions and contracts. The Freelance Act establishes common rules for such diverse transactions across industries as far as possible. The Freelance Act establishes 2 obligations and 7 compliance rules to ensure the fairness of transactions, as well as for obligations relating to the improvement of the working environment, which are imposed on undertakings that do business with freelancers. We will not present the whole picture of this law here today. The overall picture is provided on the last page of the materials. Today, I would like to focus on the part of the JFTC that is in charge of ensuring the fairness of transactions, and also on the contents that may be particularly relevant to the entertainment and creative sectors. In addition, in today's explanation, legal definitions and detailed legal explanations will be largely omitted. As a rule, we will not explain the law, such as what the provisions of this law are, what the exceptions are, and so on. For this reason, some of the explanations may lack accuracy. For detailed legal definitions, etc., please refer to the documents available on the website of the JFTC. The same applies to the term freelance. The term freelance is not used in the Freelance Act. The Freelance Act defines freelancers as specified commission business operators, as I mentioned earlier. However, if I refer to freelancers as specified commission business operators in my explanation, you, the listeners, will lose track of what I am talking about. For this reason, I will replace the term specified commission business operator with freelance when I speak. Let us now look at the content. The first obligation imposed on businesses that commission work to freelancers is the obligation to clearly state the terms and conditions of the transaction. Businesses that outsource work to freelancers must immediately give the freelancer a written order in paper form or specify the terms and conditions of the transaction via email or social network messaging services. I would like to make 2 points regarding this obligation that I would like to draw your attention to, in particular in the arts and entertainment sector. The first is that the terms and conditions of the transaction must be made clear immediately after the order is placed. In the arts and entertainment sector, it may be the case that they commission the work begins, and the details are decided later on as they work. It is also possible that the final terms of the finished product may change frequently. The law adopts a system whereby, when commissioning work, the two parties first agree on the terms of the transaction well in advance, and the terms and conditions of the transaction are made clear immediately after the work is commissioned. As a result, it is not possible, in principle, to decide on the terms and conditions afterwards. This does not apply if there are valid reasons for not being able to decide at the time of commissioning. However, the Freelance Act does indicate that it is important to clearly state the terms and conditions of the transaction at the time of commissioning the work. The second point concerns the scope in which this obligation is imposed. In freelance trading, it is often the case that not only a company, but also a freelancer, outsources work to another freelancer. This may not be the case when the competence of a particular person is important and the work is outsourced. However, even in the entertainment and creative fields, it may happen that a freelance photographer outsources some of the work he or she receives to another photographer. We have heard that the production of a piece of work may be undertaken by one freelancer, who then outsources the work to a number of freelancers to produce the piece of work. This obligation to clearly state the terms and conditions of the transaction is also imposed on these freelancers who outsource work to freelancers. When explaining the purpose of this law earlier, I said that the Freelance Act was designed to ensure fairness in transactions and applies to transactions between an organization, the client, and an individual, the freelancer. However, only this obligation to clearly state the terms of the transaction also applies to transactions between freelancers. The reason for this is that the Freelance Act was enacted to ensure fairness in freelance transactions. The most fundamental and important way to ensure fairness in transactions is to clearly state the terms and conditions of the transaction to freelancers. What work will be done, from when to when, how much will I be paid for that work, and when will I be paid? In order to prevent troublesome disputes that may arise later on as a result of verbal agreements on these terms and conditions of business, it is not enough to impose this obligation on companies alone. For this reason, even in transactions between freelancers, the obligation to clearly state the terms of the transaction is imposed on the freelancer who places the order. We have heard from people in the industry that the party placing the order told us that they have never received the request in a form that can be saved as text, and that they were asked to do the work only over the phone. We don't even know what we have to do by when or how much we will be paid. When I found out, the remuneration was transferred to my bank. By imposing the obligation to clearly state the terms and conditions of the transaction, this will be prevented and eliminated as far as possible in the future. The matters that have to be explicitly stated are written in slides 1 to 9 of this slide. Some may think these items are too many, while others may think they are not enough. For our part, we have set these out as the minimum items that we believe must be decided upon when doing business. Let me explain some of the issues and concepts behind some of these matters. The first is 3. The contents of the services and benefits to be provided by the freelancer. This is, in essence, what kind of work is ordered to the freelancer, i.e. the contents of the work. This needs to be stated specifically and clearly, not in the abstract. In the entertainment and creative fields, we hear that there are many problems related to copyright. When work is outsourced to freelancers, copyright and other intellectual property rights may arise in the course of the work. If the party placing the order transfers or grants intellectual property rights to itself beyond the scope of use for the purpose of the outsourcing, it must be clearly stated in the contents of the benefit that the intellectual property rights are to be used within such scope. The next point to pick up on is point 7, the amount of remuneration. The amount of remuneration is another matter that must be clearly stated. If intellectual property rights arise when outsourcing work to freelancers, and if the outsourcing includes the granting of the freelancer's copyright and other intellectual property rights along with the deliverables, the compensation for the granting of the intellectual property rights must also be clearly stated as remuneration. Freelancers, especially those working in the entertainment sector, will be concerned about expenses. We have heard that problems sometimes arise when it is later discovered that, although remuneration was stipulated, the remuneration did not include expenses at all, or that the remuneration did, in fact, include expenses. There was a very lively discussion on this point at the expert panel examining the government ordinance and regulations on the Freelance Act. As a result, it was decided that if the client side bears the costs and other expenses incurred by the freelancer in the outsourced work, the total amount of remuneration, including the amount of such expenses, must be clearly stated as the amount of remuneration. However, when outsourcing work, it is sometimes unclear whether expenses will be incurred or not, or the amount may not be known. Imagine, for example, transport costs to get to the workplace or covering the cost of materials in the production of props. In such cases, it is permissible to state explicitly, for instance, that the costs will be reimbursed on an actual cost basis. For more information, see, for example, the JFTC's guidelines. In any case, it is advisable for both the ordering party and the freelancer to discuss and decide on the cost aspects thoroughly prior to commissioning the work. Next, I will explain the obligation to pay remuneration on the due date. As noted on the slide, the party placing the order must fix a due date for payment of the remuneration within the shortest possible period of 60 days, calculated from the date of receipt of the service, or the date of receipt of the ordered goods, etc., and must pay it by that date. This obligation and the 7 prohibitions and compliance requirements described next are not imposed on freelancers who outsource their work to freelancers. These are obligations imposed on companies and businesses with employees when they deal with freelancers. As indicated by the arrows on the slide, the remuneration must be due and payable within the shortest possible period of 60 days. If you do not set a payment date, it is a violation of the Freelancing Act. Furthermore, in such a case, the due date for payment is the day the work is accomplished. In other words, the client must pay on the day the commissioned work is actually delivered. This means that if the payment is properly set out, it should be paid as soon as possible within 60 days from the date of receipt, but if this is violated, this period of grace is lost. If the due date for payment is set beyond 60 days, say 100 days later, this, too, is a breach of the Freelance Act. And in this case, the payment must be made within 60 days, in essence the day before the 60th day counting from the day the work was delivered. With regard to payment deadlines, there are 2 points of particular note in the entertainment and creative sectors. The first is the exception to recommissioning. In the performing arts sector, we hear that the transaction structure is multi-layered and that there is often a recommissioning from one large company to another, and then from that other company to a freelancer. The Act provides for an exception for recommissioning with regard to the payment due date. See the diagram on the slide. If a company or other business subconsigns all or part of the work received from the original client to a freelancer, if it is clearly stated to the freelancer in advance that this work is a re-commission, the name of the company of the original client, and when the remuneration is due from the original client to the business recommissioning the freelancer. The due date for payment of remuneration for work recommissioned to freelancers is not 60 days as mentioned earlier, but the due date for payment of remuneration within the shortest possible period of 30 days starting from the due date of the original commissioner. The purpose of this exception to recommissioning is that there are many small companies among the clients who ask freelancers to do work for them. The purpose of this exception is to prevent such companies from losing their cash flow and refraining from placing orders with freelancers. There are some points about this exception for recommissioning that are often misunderstood. First, this recommissioning exception is not a rule that always applies. The ordering company can also pay according to the normal payment due rules without using the recommissioning exception. On the other hand, if the ordering company mentions the recommissioning exception, freelancers should carefully check that the necessary stipulations for the application of the recommissioning exception are properly clarified. A second point concerns the case where, hypothetically, remuneration has not been paid by the original commissioner to the intermediary operator on the date it was due. Even if payment is not made in this manner, the payment to the freelancer will still be due within 30 days of the scheduled payment date set with the original commissioner. It does not matter what date the payment was actually made by the original commissioner or whether the remuneration was actually paid or not. When I recently lectured at a freelance law workshop organized by Association of Arts Workers Japan, I was asked a question regarding the due date of payment individually. Let me present this to you. This consultant said that, until now, remuneration had been paid within 10 days from the date the work was completed. So, the consultant was concerned that the Freelance Act states that remuneration is due and payable within the earliest possible period of 60 days, and that if the Act comes into force on the 1st of November, payment will be delayed. With regard to these concerns, the Freelance Act states that the due date for payment of remuneration is to be set within as short a period as possible, not exceeding 60 days. If the client and the freelancer have had continuous business before this law came into force, and a new payment date is set later than the currently set payment date, solely because this law came into force, it is not considered to have been set within the shortest possible period. This would be problematic under the Act. Next, the prohibited acts are explained. The Freelance Act states that companies and other businesses that commission freelancers for more than 1 month are prohibited from committing the 7 acts described in the slide. These 7 acts are explained in turn. The first is the prohibition against refusing to receive the work. This means refusing to receive something, such as a design that has been commissioned to be produced by a freelancer even though the freelancer is not responsible for it. For example, a freelance is commissioned to produce a certain design, but when it comes time to deliver it, the client refuses to accept it, saying, "I no longer need it because the project for that design itself has been discontinued and cancelled," and of course does not pay the freelance. This is prohibited because it falls under the prohibition of refusal to receive. Next is the prohibition on reductions. This refers to later reducing the amount of remuneration that was due to be paid, even though the freelancer is not responsible for it. For example, let's say you order a freelance photographer to do a shoot for 100,000 yen. However, the budget for the project is later reduced and the ordering party's budget has become tighter, so instead of 100,000 yen, they pay 80,000 yen. Only 80,000 yen is an example of a reduction. If the freelancer has been explicitly told that the client will bear the costs, but the client does not pay those costs, this is also a reduction in the amount of remuneration, and is a prohibited reduction. The next is beating down prices. This means the unjustified fixing of an amount of remuneration that is significantly lower than the consideration normally paid. This consideration normally paid is the price generally traded in the market. For example, setting the price of a job that would cost 10,000 yen if done normally by anyone else at 1 yen is an example. This is an extreme example, but it does not mean that only such extreme cases are covered. An act of setting the price unreasonably low without any consultation with the freelancer and without regard to the market price is also an example of unfair beating down prices. Next is the prohibition on returns. The prohibition on returns prohibits the return of items made and delivered by the freelancer, even if the freelancer is not responsible. For example, the Freelance Act prohibits a client from commissioning a freelancer to make clothes or other items, having them made, and then returning the clothes to the freelancer after delivery, on the grounds that the project itself has been discontinued and the clothes will no longer be used. Next is the prohibition of forced purchase or use. This is forcing someone to buy something or use a service specified by his client company without a justifiable reason. For example, forcing a freelancer to buy tickets to an event organized by a company that has outsourced the production of a program to a freelancer constitutes forced purchase or forced use. Next is the prohibition of requests for the provision of undue economic benefits. This is an act that forces freelancers to provide money, services, or other economic benefits to the party placing the order, even though there is no benefit on the part of the freelancer. For example, the Freelance Act prohibits the ordering party, which outsources work to freelancers, from making the freelancers offer money, such as sponsorship money, uniformly. Also, if a TV program production company outsources the production of a program to freelancers and has an agreement to transfer the intellectual property rights of the program to the client, but also transfers the intellectual property rights of various materials not used in the program for free, this may be considered a request to provide undue economic benefit. The last and seventh of the prohibited acts is the prohibition against unjustified changes to the content of the services or unjustified redoing of the work. This one prohibits the company from changing the content or making the freelancer redo it when the freelancer is not responsible. Of course, this law does not prohibit the freelancer from redoing the work because of a mistake in the work he or she has created. However, if the freelance worker has checked with the client and received an OK, and then later the client says that the work is wrong and has to redo it, this is problematic. Another problem arises when a client unreasonably forces a redo after having produced something that was initially specified in the terms and conditions of the transaction. In the performing and creative fields, there may be a lot of redoing. As the order is evaluated according to the standards as well as values of the party placing the order, it may be impossible or difficult to clearly state these at the time of placing the order. In such cases, if the party placing the order says that the work is different from what was requested and makes the freelancer redo the work, there is no problem as long as the party has full discussions with the freelancer about the cost of redoing the work and a fair share of the cost is decided upon and paid. However, if the burden of the costs is unilaterally determined and the freelancer's interests are unjustly prejudiced, this may be a problem under the Freelance Act. Finally, although we do not have detailed slide to present, we would like to introduce some future initiatives of the JFTC. The Freelance Act will enter into force on the 1st of November this year. There are only 4 months left until it comes into force. The JFTC considers that the most important task during these 4 months will be to raise awareness and publicize the Act. The development of the guidelines was completed with their publication on the 31st of May. Currently, the JFTC is stepping up its efforts to publicize and promote the Freelance Act as part of the first phase of a period of improved publicity. As you may have seen on the internet or on the screens of the Tokyo Metro, we have been conducting publicity activities, including a tie-up with a well-known illustrator and cartoon blogger. In fact, we were going to broadcast that video clip today, but I was so nervous that I forgot to bring the video data with me. I have no excuse to make to my subordinate staff. We were supposed to play a 50-second video. I failed. I hope you will visit the JFTC's website and watch the video. We believe that the number of people who have heard of this law is increasing, but when it comes to those who know exactly what the law says, there is still a long way to go and our efforts will continue to be needed, and we will continue to do our best to publicize the law. Secondly, once the law comes into force on the 1st of November, we need to make sure that we crack down on companies that are in breach of the law. We call this the enforcement of the law. We need to create an environment that makes it easier for freelancers to report violations when they occur, and to do this, we need to establish a government-wide contact point for reporting, not just at the JFTC. In addition, Freelance Troubleshooting Helpline 110, which is already open for consultation, will continue to be maintained here as well, by organizing and guiding people in an easy-to-understand manner on how to make a reporting. Finally, I would like to talk about the freelance trade in the entertainment and creative fields. As I mentioned earlier, I arrived in charge of this Freelance Act in September last year, and since then I have heard from many people. In doing so, I have found the variety of ways of working as a freelancer to be both very important and a challenge when considering the various transactional issues that freelancers face. Some people may have chosen freelance work because they want to pursue a free way of working or don't want to be tied down by a company, while in some industries freelance work may be the only option. We are learning every day that freelance working is very, very diverse, depending on the individual, the industry, and even within that industry, including whether freelance is the only way to work. In order for us to watch these freelance transactions closely, I feel that it is important to understand the reality of transactions in each industry, which vary from individual to individual and industry to industry, and to enforce the law appropriately. Including today's symposium, we will continue to listen to the opinions of many people and work towards the fair freelance transactions. That is all from me. Thank you very much for your attention.